better conversation. So thank you. We're really excited about it today. Welcome aboard to the Klamath, the headquarters of the Bay Area Council. My name is Adrian Covert. I'm Senior Vice President of Public Policy at the Council. Among my several hats, I manage our Homelessness Committee, along with my co-chairs for that committee, Elizabeth Funk, who's moderating our panel today, as well as Tom Wolf, who represents the Salvation Army. So let me just mention a few housekeeping items, and then I'm going to turn it over to Elizabeth and our panelists. First, you may have noticed we are on a boat. We move from time to time. The restrooms are down that aisle, down the hallway from which you came, past the door that you came down, to the left in case you need it. Normally we have this door out there for fresh air, but some seagulls recently started nesting. There's a family of chicks. It's a whole ecosystem here. The Bay Area Council's homelessness advocacy began about 6 years ago under our then chair, Bernard Tyson, the late Bernard Tyson from Kaiser Permanente. And since then, we've been dedicated to advancing policies to not only solve the symptoms of homelessness, but also address the root causes, from housing abundance and housing scarcity to the lack of shelters, needlessly increasing trauma among our homeless populations on the streets, and also addressing the substance use disorder pandemic in California and the rest of the United States. I'm very excited about today's conversation about the recent Supreme Court decision, which we'll get to in a second. But first, I'm going to use my role as host here to raise awareness on two pieces of legislation that the Bay Area Council is co-sponsoring that's in Sacramento right now for your awareness. One is SB 1395. This is a bill by Senator Josh Becker that the Bay Area Council is co-sponsoring with Dignity Moves and San Jose Mayor Matt Mahan and Spur. This bill is all about making it easier for local jurisdictions to scale up low-cost, non-congregate interim housing. It's the missing rung on the ladder between the streets, shelter, and permanent housing. These units can be scaled much more cheaply than permanent housing and is our best chance at addressing quickly the unsheltered crisis on the streets to bring people indoors and save lives. The other piece of legislation we're working on is AB 2893. This is a bill that's co-authored by Assembly Members Ward and Haney, and this addresses the lack and the shortage of recovery housing. So drug-free recovery housing for folks with co-occurring homelessness and substance use disorder who seek sober environments to assist them with their recovery. Under California's current Housing First laws, the state programs can't go to fund those. And that's in violation, or it's non-conforming with Obama administration policy and Biden administration policy on what Housing First should do and should be allowed to fund. Recovery housing, AB 2893. Both of those bills are currently going through the legislature now. If your organization is in a position to take positions on legislation, we urge you to consider those. Happy to answer questions after. Without further ado, let me introduce today's panelists. Bradley Hamburger is a litigation partner in the Los Angeles office of Gibson, Dunn and Crutcher. His practice focuses on class actions and complex litigation in both trial and courts on appeal. Thene Evangelis is a partner in the Los Angeles office of Gibson and Dunn and Crutcher, LLP. She serves as co-chair of the firm's global litigation practice and previously served as co-chair of the firm's class action practice group. Both Thene and Bradley argued before the Supreme Court representing the city of Grants Pass. We're thrilled to have you today to talk about the case. David Casarubias Gonzalez is senior counsel at Hanson Bridget, where he focuses his practice on public agency litigation with an emphasis on complex matters, class actions, and multi-party litigation. David helped lead the charge for the Bay Area Council's amicus brief on the case. And Elizabeth Funk is co-founder and CEO of Dignity Moves, an early innovator of the interim supportive housing I was talking about earlier, which is taking root across the state and is a co-chair of the Bay Area Council's Homelessness Committee. So with that, I hand it to Elizabeth and to our panelists. Oh, and also, by the way, if you hadn't noticed, We have some statistics on homelessness and some charts that are going to be running on loop throughout the conversation. If you want to see these slides after, just let me know. Elizabeth, take it away.
Thank you, Adrian. And I'm glad to see everyone. And thank you for your interest in this very important topic. Obviously, unsheltered homelessness is one of the biggest crises that's facing our state and our nation. And this recent ruling has very pivotal impact on the way that cities and counties are able to address a very pressing problem. So I'm excited to learn from the experts today. I'm going to start with DNA. So just set the stage for us and tell us about, in general, what the recent grants passed, Johnson versus Grants Passed ruling was, and what its implications are for cities and counties.
Well, thank you, Elizabeth and Adrian and all of you. Thank you for having me. It's a pleasure to be here with all of you, and thank you for your support in our case. It is such an incredibly important decision from the Supreme Court. We were so pleased to see that the court agreed with our arguments. So I'll start by saying what was at issue in the case. Grants Pass, Oregon is a small city of 38,000 people, but dealing with some of the very same problems that we're dealing with here in San Francisco and where we live in Los Angeles, problems of unsheltered homelessness and the inability to really get people the help that they need as a result of the Ninth Circuit's, the Federal Court of Appeals that covers San Francisco, California, Oregon, and the entire Western United States, 9 states. The court held that Grants Pass could not rely on its camping ordinance. It enjoined enforcement of the camping ordinance. And it said that that violated the 8th Amendment's prohibition on cruel and unusual punishment because Grants Pass did not have enough adequate shelter beds for everyone experiencing homelessness in the jurisdiction. And what that did was really put courts in charge of homelessness policy. So this wonderful public-private partnership that you see here, and that I'm so happy to see with what your organization is doing and all of you here at the Bay Area Council and so many cities across the country, but here on the West Coast, that policy debate, the need to really address all of these issues in our local communities, that was frozen. Cities' hands became tied. The Ninth Circuit held that cities could not regulate camping. And as a result, what we've seen is that people are remaining unsheltered. That problem that you talked about, the problem of unsheltered homelessness, really the harm that comes to people trapped in encampments and those in the broader community, that really is what we've seen increase over the last 5 years. We're going to get to where this all started, but the decision in Grants Pass really was so problematic for cities all across the Western U.S. and led to an injunction against the city of San Francisco, tying its hands as well. So we asked the Supreme Court to grant review, and we had the support of thousands of cities across the country, the Bay Area Council, the U.S. Chamber of Commerce, and so many business groups, cities, and others. Governor Newsom, Mayor Breed filed briefs in support of us because, as they explained, it's not compassionate for cities to leave people in these conditions, and that they need to be matched with services, with shelter, with both immediate and interim and permanent, hopefully, solutions. But all of that is very complex. And so the Supreme Court reversed the Ninth Circuit's decision, and it restored to local cities the ability to debate these complex issues. And that's really what this case is about. California was an outlier. The Western U.S. became an outlier over the last 5 years, different from the rest of the country. These camping laws at issue in Grants Pass and here in San Francisco and other places are the same kinds of laws in effect all over the country. And the Supreme Court's decision pointed to that. It said a majority of cities have laws just like this. They're basic city functions to protect public health and safety. And so the Ninth Circuit's decision really tied cities' hands. So the Supreme Court on June 28th, very, very recently at the very end of the term, reversed the Ninth Circuit's decision. And in doing so, I think has really given us an opportunity. The opportunity is huge to really solve this crisis. And I think cities are leading with compassion, and they are doing everything they can to really help people. And so that's what makes me happiest about the result here.
Well, you've alluded to this, but Grants Pass is really downstream of an earlier ruling, Martin versus Boise, that I'd like to ask David to expand on. I can tell you from my perspective as Dignity Moves, the Martin versus Boise precedent was so confusing for cities that quite frankly, they were using it almost as an excuse to not address unsheltered homelessness. I had too many city council members say, we can't clear the encampments, the court won't let us. And it's not true, right? The courts weren't letting, but they didn't understand. It wasn't clear. They were so subject to suits based on that legal precedent that it was quite frankly creating a frozen and inaction. And so can you explain a little bit more about Martin versus Boise and what was the precursor to this Grants Pass ruling?
Sure. So Martin was a 2018 case out of Boise, Idaho. It was 6 homeless individuals who sued when the city of Boise tried to enforce their local ordinances against camping and sleeping in public. Their primary argument was that they had no alternative. They had to sleep in public. And so criminalizing their doing so was a violation of the 8th Amendment's cruel and unusual punishments clause. The Ninth Circuit agreed with the 6 homeless individuals and held that if there is no alternative shelter available, cities like the city of Boise cannot criminalize sleeping and camping in public. Now, on its face, it seems like a very noble decision, but as applied, boots on the ground, it actually wreaked some havoc and caused some chaos because there was a series of other federal district court and state court opinions that followed Martin, where the courts were trying to grapple with what does alternative shelter mean? And so the case law developed to require adequate alternative shelter. What does adequate alternative shelter mean? So if an individual has a substance use disorder and the shelter does not allow drugs or alcohol, then that individual could argue in court, well, that shelter, although it's available to me, is not an adequate shelter because I have a substance use disorder. Similarly, individuals with pets, the city could offer an individual a shelter bed, but the shelter does not allow pets. And so the individual would say, well, that is not an adequate alternative shelter to me. Therefore, I should be able to sleep or camp in public. And you cannot criminalize that because it would otherwise violate my 8th Amendment rights.
Like someone put in jail. And yet on the other hand, being able to offer someone an alternative is very different. But could you elaborate a little bit about what the specific what the point is?
Yeah, so we're lawyers, but the problem here was that lawyers were getting involved in a problem they shouldn't, and judges more particularly, were getting involved in a problem that they should not be attempting to solve. And they really were creating a paralysis, largely because of the adequate shelter debate. What does it mean to be adequate? That just any good lawyer could take that word. It's so amorphous and argue it every way. And then the side effect was, as has been mentioned, is the cities were then pointing that cities that didn't want to do things, didn't want to make the hard decisions, would point to the courts won't let me do it. So how did we get here? Because so this is the law diversion. Unfortunately, that's my task, is to give you a little bit of law, because this is a 8th Amendment case, has been mentioned. Cruel and unusual punishment. Most people, when they think of the cruel and unusual punishment clause, what they think of are things like the death penalty, life imprisonment for minors, torture, things like that. And generally, that's what most Supreme Court decisions interpreting the cruel and unusual punishment clause are about, with one exception. And the whole case became about the one exception. It was a 1962 case involving a California statute. This case was Robinson versus California, a very strange California statute. The statute prohibited not the possession of drugs, not the use of drugs, not the sale of drugs, but it made it illegal to be addicted to narcotics. And the Supreme Court held in that decision that was a violation of the cruel and unusual punishments clause, it's kind of interesting. Justice Gorsuch, who wrote the majority opinion in Grants Pass, goes through how this argument was barely briefed, not even mentioned at oral argument, kind of came out of left field, because before the Robinson decision, the cruel and unusual punishments clause had never been viewed as a substantive check on what states or municipalities could make illegal. But Robinson exists. It held that statute, where just prohibiting somebody for being an addict, making it illegal to be an addict, was punishing somebody for just being an addict. That was cruel and unusual. The opinion itself on its face made pains, very careful to distinguish between conduct of selling or possessing or using narcotics. But despite those limitations on the face of the opinion, the plaintiffs in our case made their entire argument about the Robinson decision. And that's almost exclusively what the debate, in the opinion, is about. The debate is whether or not this ordinance, which doesn't, if you read just the media coverage, you would think that Grants Pass's ordinance here was, it is illegal to be homeless in Grants Pass. That is not what the ordinance said. It said it's illegal to camp in public areas in Grants Pass. If I wanted to put a tent up and camp out for 2 weeks in the park in Grants Pass, I would not be able to do that. Justice Gorsuch points that out in his opinion, that this isn't a law like the law in the Robinson case that made it illegal to have a particular status, in that case addiction, here homelessness. Instead, what this ordinance was about was regulating the use of public spaces generally for anybody. And the whole debate between us and our opponents and the majority opinion and the dissenting opinion is whether or not an ordinance like the ordinance at issue in Grants Pass is the same as an ordinance like the one in the Robinson case. And thankfully, the court concluded it was not. There's one other decision, and I'll wrap up these remarks, that's really important, which is 8 years, I think it was 8 years later, maybe it was 6 years later, there was another opinion trying to, that applied the Robinson decision not to addiction, a statute prohibiting addiction, but a statute prohibiting public drunkenness. And the argument there was very similar to this one, which was, well, if you are prohibiting me from being drunk in public and I'm an alcoholic, you're actually prohibiting me from being an alcoholic. And there was an opinion by Justice Thurgood Marshall for the court saying, no, that is not the same situation as Robinson. Being drunk in public is an act. It may be caused, maybe linked to a status, but it is not a status itself. And that was the distinction that the court made in 1968. And in the Grants Pass opinion, that's essentially what the majority says. It says, well, the reading of the Powell decision, we've rejected that. Justice Marshall rejected that back in 1968.
So, Theodine, I'd like for you to summarize for us what the opinion of the court was and also the dissent.
Sure. Well, it really goes back to what Brad was just talking about. I mean, the opinion of the court was effectively really adopting the view of Justice Thurgood Marshall in 1968 when it comes to the Eighth Amendment and what is the line between status and conduct. So the plaintiffs in our case had tried to move that line, and the court reasserted it. And what it means is that a basic ordinance like the one in Grants Pass, which, by the way, that ordinance is a civil ordinance. So in Grants Pass, like in most places, it's the punishment, if you will, is a ticket, a citation. So it's a civil ordinance, and no one's going to jail. None of the plaintiffs in the case had actually been, cited for anything beyond a civil, citation. So it really, I think, has been maybe not portrayed as accurately as it should be. So I just wanted to be clear about that. But the court held that the Eighth Amendment does not prohibit the enforcement of camping ordinances. And it held that camping is conduct, it's not status. And that rested really on all of the amicus briefs that explained to the court that, you know, the issue of homelessness is so complex. And I said this earlier, but I will say it again. A person's status, if you will, from one day to the next could go from sheltered to unsheltered to a whole variety of things. And there may be a whole host of reasons why a person is maybe unwilling to accept shelter, or maybe they don't have it. But if it's offered, you know, may the city say you have an obligation to take it, and you may not camp here, for example. The court said that cities are within their traditional powers as local governments to regulate public spaces, and that's necessary. And a lot of, you know, they heard from Amiki about how these ordinances are important. And so really the legal question in this case, and I said this at the argument in my opening and in my rebuttal again, that the legal questions in this case were actually relatively straightforward. But the policy questions are not. As we all know, that's where the hard work is, and that's the complexity. And that's precisely why the court said that courts should not be in charge of homelessness policy, and that ability to decide what policies a city or local government or state government wants to adopt, that remains with the people and their elected representatives.
So our primary focus for the Bay Area Council was not to echo the arguments of the parties on the merits, but to actually give the court insight into what's actually happening on the ground in the Bay Area so that they could have a perspective of the real world impact that this opinion was having in the community. So the Bay Area Council, along with a dozen other business groups, wrote in favor of overturning the Grants Pass decision and explaining really the dire situation facing the Bay Area. This is, like's been said before, such a complex problem, and it really is best suited for local communities to address because it's just so different. San Francisco is very different than Grants Pass, than the city of Boise. San Francisco's homelessness problem is not limited to San Francisco. It's a regional problem. And so we have very different perspectives and very different interests when explaining to the court why this decision was so problematic. But many others also wrote on behalf of their various interests, including, as was mentioned, Governor Newsom, Mayor Breed, a host of cities and counties, leagues of cities, national leagues of cities and counties. And it was really across the political spectrum. Everyone was jumping in to explain this is a bad decision that needs to be reversed because it's fundamentally flawed.
If I might add, I don't think I mentioned this, but this was so striking about the court's opinion. I've never seen this in all my years of practice, and I've been practicing for a long time. The court cited the amicus briefs 64 times in its opinion, and that's really unheard of. But the court was really listening to, and you know, these amicus briefs really mattered. So thank you again. They really explained to the court what was going on the ground and what the real life consequences were. And that's why, you know, again, this was not a political issue. We had Governor Newsom and Mayor Breed, you know, we had the editorial page of the Washington Post and the Wall Street Journal all on our side, because I think that it was all of these amicus briefs and all of the experience on the ground has taught us that this really is an issue about helping people and about allowing our cities to do the work that they need to do.
The coalition of Miki was really, I mean, it was really striking. It really was Big Tent. I mean, we have Newsom and Mayor Breed. We also had a coalition of red state attorney generals. It's probably the only thing that Gavin Newsom and the attorney general of Texas agree upon is this case. And then we also had people that were impacted by encampments, and the court relies on one brief in particular, which I think it was really effective, which was a brief by disabled individuals in the city of Portland who had actually sued the city of Portland because they could not use the sidewalks because they're filled with encampments, and so there's externalities here for other people, and the court took notice of that. in addition to all of the what all the municipalities and states were saying.
Well, I'd like to start thinking about now what this means for cities and counties and what they can and can't do. And I can say from my experience, the best thing is that the decisions are back in the hands of cities where they can actually now set their own policies. And certainly there will be cities that will set bad policies. And I think we all know that getting people deeper and deeper in debt or putting them in jails are going to be costly solutions. And those are going to end up not being very effective, right? Right answer is to build enough beds and get people into places where they can thrive and hopefully solve their problems. There are concerns in some cities like San Jose, for instance. Mayor Mahan is very concerned that some cities are going to just outlaw public camping, driving everybody to the bigger cities that don't have the beds to accommodate them. So I think it's going to need to be regional solutions. The right answer is building more beds rather than truly criminalizing, but then being able to hold people accountable to accept them. So now that the ball is back in the cities and counties courts, what can they and what can't they do that they couldn't do last month?
So I'll give you an example of something that the federal government does in Washington, D.C. So I think this was an example that the Supreme Court relied on in its decision. In McPherson Square, not far from the White House, there was a really dangerous encampment, dozens of tents. There were deaths, there was a murder, there was drug activity, and the federal government, the Park Service that has jurisdiction, went in, they gave people notice, and they first found that social workers were unable to get people connected with shelter and services. It was too dangerous for them to go out and actually do the work that they needed to do to help people because it was so unsafe and unsanitary. But they gave people notice and they enforced the same exact law that Grants Pass and San Francisco and others have, but they were able to move people because they had that ordinance to point to, or in that case, a federal regulation, which mirrors the exact laws we're talking about. They got them all into shelter and services. And that's what we want. So San Francisco reports that 50%, unfortunately, of offers of shelter are refused. So that's what you mentioned, Elizabeth, about holding people accountable. That's what cities can do now. So they have that full toolbox available. And that's really what this is about. But again, the mix of all of the different, types of housing. There's a big debate about the, emergency shelter versus interim housing, the piece that's missing, and then the permanent housing. All of those are necessary, and cities need to come up with their mix, and it needs to be a regional solution for sure, and a statewide solution. And that's why, our state and local governments are all, working toward the same end, which is to move people indoors into safe housing and services that will help save lives. So I think that's what it means. It's actually pretty simple, that it's just restores that ability now, the flexibility.
Yeah. And before last month, or before 2 weeks ago, if you try to clear an encampment, even if you did it through, which most jurisdictions do, at least the larger ones, with offers of assistance, help, shelter, you would get a lawsuit potentially. And the lawsuit would be based on fighting what the adequacy and the availability of the shelter offers. I think most jurisdictions, as you mentioned, are not going to do what the dissent said, that we're going to just criminalize homelessness. That's not what this is about. What this is about, I think, is having a mix of incentives and encouragement for people that where a shelter offer is not their first choice. But if they're their option, they're not going to have the option to just say, no, I'm not going to accept that. I'm going to go sue you. And we're going to entrench people living out in encampments, which are not good for anybody. They're not good for the general public. They're not good for the people living in the encampments. But I think what this does, hopefully what this will do, is that the courts will be out of the business of micromanaging these policy decisions. You're going to give governments back the power they've always had up until now. Is this decision going to solve homelessness? No. The work now starts. It's a political issue. It's political. And the one commonality, I think, among the majority opinion and the dissent is that it's a complex problem. And when you have a complex problem, the law is usually not the solution. The solution is the political process, the policy process. And I think one interesting thing maybe we want to talk about is, what's going to happen with laws that have been put on the books while the Martin regime was in effect.
Yeah.
Because there are jurisdictions that changed their laws because they felt they needed to, because of the Ninth Circuit, I think there are going to be debates about, even in Oregon, for example, is probably the one of the first ones that'll happen. A debate about changing the laws that were enacted because they, states or municipalities thought they had to conform to the Martin regime.
Well, there was a great example in Los Angeles, the LA Alliance for Human Rights, that the LA Alliance sued the city and county mostly because they were very confused about the Martin versus Boise ruling and needed a federal judge to give them some sort of guidance. And that was interesting, where the judge said, all right, you can enforce in your district or in your city as long as you have 60% of the number of beds of your last point in time count. 60% started as sort of arbitrary, but it turned out in practice to be the right amount. And we don't realize this up here, but something like 19 cities in LA County have done just that, where they've built enough beds and then they've made those offers and then they have declared that it is illegal to sleep inside their city, and it's working. And so what we're finding is cities are now saying, okay, I'm going to build my interim housing and I'm going to make valid offers. And then I am going to reward that neighborhood with that being an enforced district and be able to have the right to do that. And I think that's when we're going to start to see the positive political forces, where you're saying to the local residents are saying, you know what, I do want a shelter because I do want people to have a place to go. And I do know that it will therefore mean that people aren't able to sleep on my streets.
That's such a great point, because what we've seen is, people have been resistant to, interim housing, bridge housing, and so forth in their communities because they know that the city has no ability to enforce under the Martin regime. But now when the city has all of those hopefully wonderful carrots, they have the ordinance, which can be the stick, and they can make sure that with that development comes also safe streets, safe parks, safe sidewalks for everyone. And so really it's win-win. So I think that was a missing piece over the last 5 years, is cities really were powerless. And I know in some cases, maybe they overstated it, but they really were getting hit with suits. There were 35 lawsuits filed against cities that we know of. And that doesn't count all those that were threatened, but the city just stopped doing what it was doing.
Confusion was really the problem. I mean, whenever you have uncertainty, anytime you're making a decision and you have profound legal uncertainty, plus you have risk of, if you guess wrong, you're not only gonna have to pay, hire lawyers, get a TRO, you might have a federal judge that's now scrutinizing everything you do. Is you had federal judges going and saying, you're in your shelters, you need to have camps, you need to allow people, or encampments, they have to be allow them to be certain number of yards apart or close, like micromanaged decisions. And then there were, of course, what makes a shelter adequate is so difficult to figure out. Where you had kind of outrageous claims that a shelter is, inadequate because it doesn't have enough medical services at the shelter. Well, okay, well, there was
the religious
thing is tricky, but yeah, if there's any religious affiliation at all, it doesn't matter. So you have a good place to go, but you can't go there. The dog example, actually, that came up at argument.
Sure. Well, this is an opportunity to give a shout out to AB 2893, where sobriety-based beds can be one of the solutions. And when we work with our cities, we talk to them about, when you're building an interim housing site, that shouldn't be your only offer of shelter. In Dignity Move's case, we build rooms where everyone has a private space, which is very attractive. But the outreach workers should also be able to offer a homeward bound ticket. They should be able to offer, if somebody really wants to be in a tent, it's in a sanctioned safe sleeping. If they want a sobriety-based bed, we have those too. Now you can have an array of choices, and somebody's going to have to take one of them because sleeping in front of Starbucks is no longer one of the choices. And I think, and I hope, and it's going to be interesting now to see which cities and counties rise to the occasion and write policies that are humane and yet enforceable and practical. We've seen in San Mateo County, for instance, if anybody would like to speak to that local law that was recently passed, and what does anybody think about those kinds of examples of now how those are going to get
What is that example?
So in San Mateo, they passed an ordinance that I have in front of me, which was that they would be able to enforce their laws as long as somebody had been offered and rejected shelter twice. So they passed an ordinance that would allow penalties, including jailing.
For repeat. Yeah. Yeah. I mean, that seems like the sort of, trade-offs of, again, offering help. I think that's wonderful that they're leading with that. I don't really know about the law, but I think, we probably are going to see a mix of sort of that, the backdrop. It's not the first move of the city to, tell someone they can't camp, but after repeated attempts to get people help. I mean, we've seen in LA, LAHSA, the Los Angeles Homeless Services Authority, goes out, over a dozen times per individual in an encampment before they give up. So think about the resources that cities are spending, sending out armies of social workers to get people help, and they don't quit until after a dozen times. I don't know if you're familiar with that statistic, but it's really surprising how many resources cities have been using when they have no sort of backstop, no ordinance to point to. And so they're just trying to convince people that it's a good idea. And it's very hard when you're dealing with, different mental health issues and substance disorders and so forth.
Yeah, I think that, well, we know from the Grants Pass decision that the Eighth Amendment is not going to constrain the choice on what kind of ordinance to adopt. So, if a city thinks that two refusals is what you need, then they can do that. The federal courts are not going to mandate that. I think the other area where you might see a reassessment would be jurisdictions that have done time, place, and manner laws. So, for example, Oregon has a statute that basically says you can't outlaw camping everywhere. You have to have it in some places. And it's basically a time, place, and manner. There basically has to be somewhere at some point you can allow encampments. Los Angeles has done the same thing. I don't know if Los Angeles will change politically. Mayor Breed was, or not Mayor Breed, Mayor Bass was, she disagreed with this decision. I guess she wanted to be constrained by the federal courts, wanted to be micromanaged by them, which, but nothing says Los Angeles has to change its law. If the voters want, if the politicians, elected officials want to do that, they can. This decision doesn't mandate anything one way or the other. All it says is that the Eighth Amendment has no application here. I also think that I think the clear message from the court is the federal courts should get out of this business. Yeah. I don't think the advocates on the other side are going to stop. So they'll try to come up with other theories. One good piece of news, just happened yesterday, was the San Francisco, the Ninth Circuit, in light of Grants Pass, got rid of the bulk of the preliminary injunction against San Francisco. But I'm sure the plaintiffs in that case will try again. They'll come up with some other theory.
Well, people do have to have a place to go. They are still humans. They are still in existence, and they do have to have a place to go. Hopefully, most cities will decide that the right way to do that is to therefore build options for people. One of the downsides is that people maybe get driven out into the environment. And we know the environmental impacts of homelessness and encampments are horrible with wildfires and pollution and so forth. And so cities that don't think big picture and strategically are going to have negative impacts, particularly, for instance, on their environment. Hopefully we will be able to start educating them before they have to learn the hard way about the wrong policies.
Yeah, I mean, I guess we haven't really seen that though in the rest of the country. So we have to, again, point to, this is just going to make us like the rest of the country. So point to Boston, New York, DC, again, different policies, different mixes, but they haven't had federal courts micromanaging things, and they've been just fine without the Eighth Amendment as a, sort of threat to every little thing that they do. So I mean, we're just going back to the status quo before the Martin decision, and we can just get back to work, and let's do what we need to do and do the hard work and really get people help. So that's my my thought here. But again, it's not, the Supreme Court's not mandating anything at all.
Well, I can tell you, I'm not a lawyer, but I am an optimist, and I agree that I think this is a turning point that is going to empower cities to do the right thing. And I think that there is a wrong answer, which is putting people in jails. It's not going to work. The right answer is to build dignified housing and options that can be done fast and cost effectively, which is what Dignity Moves is about. But variety, like for instance, the law about offering, sobriety-based beds as one alternative. And I think it is up to cities now to create policies where people build enough dignified solutions that are attractive and meet the needs so that no one needs to resort to, and nor will they be allowed to sleep on our streets. And this will empower that. Thank you.
And I just want to say thank you. Thank you to all of you, and thank you for all that you're doing. It's really wonderful. It's so encouraging to hear this conversation. So thank you.